May I please, my lord?
Yes,
Lordship, item number 7, Lordship.
yes.
Lordship, here I have instruction to appear on behalf of respondent number 2, Lordship.
Respondent number
2, Lordship.
2.
Yes, I have already been appearing for respondent number 1.
Okay.
So now I'll be appearing for both respondents. The service may kindly be deemed complete, Lordship.
Okay.
And kindly grant me 3 weeks' time.
Okay. Mr. Takamatsu, Takakechulana, counsel for the petitioner is present. Mr. Angami, who earlier appeared on behalf of the respondent number 1, is also would appear on behalf of the respondent number 2 and prays for some time. Stop. The prayer is allowed. List this matter after
3 weeks, Lordship.
3 weeks. Okay.
Please, your lordship.
Yes.
Lordship, I beg to mention item number 5.
5.
Yes, lordship.
Okay.
Lordship, on the earlier occasion, we have prayed that we will be filing our Vakalatnama. However, due to some technical reasons, we failed to file our Vakalatnama. If 1 week's time can be given to rectify the same, we are for the respondent number 1.
You will be appearing for respondent number 1.
Yes, lordship.
Vakalatnama not yet filed.
In the last occasion, we have prayed that we'll be filing our Vakalatnama.
Not
However,
yet filed.
Yes, lordship. There was some technical issues. So if 1 week's time can be given to rectify.
You are for the appellant.
Yes,
Okay. Miss
here to learn.
Lana counsel for the appellant is present. Mr.
No more on behalf of respondent number 1.
Appearing on behalf of respondent number 1, prays for some more time to file Vakalatnama on behalf.
Respondent number 1.
Okay, respondent number 1. The prayer is allowed. List is matter. After
The usual.
after 2 weeks.
After 2 weeks.
Okay.
Lordship.
Is prayed for. List is matter after 2 weeks. Okay.
Lordship, I also would like to mention item number 10, 11, 12, and 13 on behalf of the appellant. This matter can come up after 3 weeks, Lordship. We've taken the consent of the opposite party. 10, 11, 12, and 13.
Okay. Mr.
No motion on behalf of the appellant.
You have any objection? No, no, sure. You are Mr.?
Yes, Imli on behalf of Wadi Jamil.
Okay. Appearing on behalf of? You are appearing on behalf of?
Wadi Jamil.
What is your name? And you are Mr.?
Yes, Imli. Yes, Imli.
S. Amy. Appear on behalf of the appellant, Mr. What is your name? Mr. His name, huh?
No motion.
Why, when do you want to say?
Lordship after 2 weeks.
Right, for listing this matter after 3 weeks. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Relations.
Yeah, please, the Lordship. Lordship, I beg to mention item number 1, Lordship.
Yes,
I'm for the respondent number 1 to 3, Lordship. Lordship, if this matter can come up after 2 weeks. Lordship. Item 1.
who is, have you informed the petitioner?
No, Lordship.
So it's the first item, it will be called. Let us wait for some time. Okay.
Please, Your Lordship.
Yeah.
Lordship, I beg to mention here in item 8, Lordship, my senior, Gauhati is indisposed, so kindly list it after 3 weeks.
Okay. Miss,
Yes, Your Lordship.
appearing on behalf of
Gauhati,
Mr.
CJ.
Younger Vatilana Counsel for the appellant, praise for adjournment of the case for today and to, and for listing after 3
3
weeks.
weeks, Lordship.
Okay.
Okay.
You are appearing on behalf of respondent here.
Yes, Lordship. Respondent number 1.
Okay, Mr. You have any objection? Land Counsel for the respondent has no objection. Prayer allowed, list this matter after 3 weeks.
Lordship, item 9, kindly pass over.
Which one?
Item 9. Item 9 and 14 also, pass over
Pass over for
for the day.
the date.
Monday, yeah. We'll be sit on Monday.
When do you want this to be
Monday.
listed? Huh?
Monday,
Monday.
Oh.
Item 9.
9 and 14 also. See?
Lordship,
Nine and
on
14.
Monday, I have some personal difficulties, Lordship. If
Next
this-
week, we'll say next week.
Okay.
Next week, Lordship.
As prayed for by Miss
Yes, Your Lordship.
appearing on behalf of Younger Vatilana Counsel for the petitioner, list this matter after a week.
After.
Okay.
9 and 14.
9 and 14 also.
Yes.
Okay.
My please, Lordship. Lordship, I beg to mention item number 4.
Item
4. On behalf of Tipa Pond. The state is here, the receipt is.
on behalf of
Tipa. The state is here, the receipt instructions, so kindly grant 3 weeks time to file affidavit.
who is for the petitioner, have you informed?
No, Lordship.
Let the matter be called for, will pass over. Okay, it won't take much time.
Lordship.
Okay,
May I please, your lordship?
yes,
Lordship, I may be allowed to mention item number 6, your lordship.
six.
For orders, your lordship. Lordship, in the last interim, your lordship, the petitioner was allowed to make changes in para number 2 by filing an application, your lordship. However, the application is yet to be filed, your lordship, if 1 week time be given, your lordship.
Okay, correction
Changes in para number 2,
Changes,
your lordship,
okay.
in the petition by filing an application.
by filing
Application, your lordship,
application.
lordship.
Mr.
I'm sorry, your lordship.
Madam Counsel for the petitioner, praise for father,
1 week time, your lordship.
1 week time to file application
Yes, application to make necessary changes in para number 2.
for making necessary changes in the para 2 of the
Petition,
petition.
your lordship.
The prayer is allowed. List this matter after
1 week,
a week. Okay.
much pleasure.
It's your Lordship.
Yes,
Lordship, I beg to mention item number 3.
3.
Lordship, here I'm for the respondents. Pleadings have been completed. If let it come up for hearing after 2 weeks, Lordship.
You are for respondent number?
Respondents.
So respondent. Okay, you are Mr.
Yes, Imli.
Land Counsel for the, is Emily, Land Counsel for the petitioner is present. Mr. His name, huh? Land Counsel for the respondent, You want this matter to be listed?
for hearing after 2 weeks. Lordship.
Okay. Prays for adjournment for the day and to be listed after 2 weeks. The prayer not objected. List this matter after 2 weeks. Okay. According.
Much obliged.
Obliged.
Okay.
Please, Your Lordship.
Hmm.
I beg to mention item number 2.
Okay.
Lordship, we're here to execute an agreement, so kindly grant us 2 weeks time.
It will not take much time. Yeah, okay, you are for the petitioner.
Yes,
What do you want?
Lordship, we need 2 weeks time to execute an agreement.
2 weeks time to
Execute an agreement. Execute an agreement,
execute?
an agreement with the respondent number 2. We've made the payment, Lordship.
Made a payment.
Yes, we've made the payment to the
Hmm.
respondent.
Okay,
So in effect to that payment, we have to execute an agreement.
execute the agreement.
Yes, Lordship.
Agreement with the respondent.
Yes.
Okay, this is question petition,
Criminal petition.
criminal petition. Okay,
Lordship, if my lord is pleased, like both the parties have arrived at an agreement.
Hmm.
There's no dispute between the parties.
Hmm.
So even if instead of going for another, all these.
Let,
things
let
are-
us see the records.
I think
now.
they can-
Wait
they
for
can
some
close.
time.
Yeah.
It's item 2 only. Lydia. No urgency. Okay. Yes,
Yes, Your Lordship,
yes.
like to mention item number 4.
Item 4.
Yes. I've been.
Somebody mentioned, I think. You have urgency? What do
Yes,
you want
Lordship,
here?
State, actually, state has sought for time.
Okay, okay, the petitioner was not present.
Yes, yes.
Okay,
On behalf
so
of.
when do you want, you say?
The affidavit in reply is under preparation. Kindly grant us 3 weeks time.
Okay, Miss,
Uh,
you are
I'm
Miss?
appearing on behalf of my senior, Nityo Kosa.
Appearing on behalf of Nitya Khoja. Nitya Khoja, Land Council for the petitioner prays for further 2 weeks time to file affidavit and reply. The respondent has no objection. Stop the prayer allowed. List this matter after 2 weeks. Okay.
Obliged, Lordship.
From the supplementary cost list for motion, item number 15.
Yes.
May I please, Lord? Please. My Lord, this is a matter against the order of DC arising out of a land dispute in Visima village. It's about 30 kilometers away from here. And it is with regard to a forest land. And the land belongs to the ancestral, land is the ancestral property of the petitioners. There is a checkered history, but I will just start from 2018.
Okay.
When it comes to the issue of land and all this in a village, the matter becomes very sensitive. Lordship is well aware, we are all from tribal areas.
Yes, yes.
So how the tribal people react to such a dispute, we all understand. Now, in 2018, a clan by name Kinau clan, they have encroached a portion of the petitioner's land. Not all, but some portion was encroached. So against that encroachment,
What clan you say?
I belong to Tsakro clan.
You belong to, you
TSUK.
belong to? Sukro.
Tsakro clan.
And encroach.
The other
encroacher
clan is Kinau clan. KENN.
is the Kenau clan or a respondent?
No, they are not.
Okay, Kenau clan.
Yes. Kinau clan has encroached a portion of Tsakro's land. So having agreed by that encroachment, normally it starts from hill. That is sector.
Okay,
And in Angami villages, their hills are consisting of their own clan.
Hmm.
So a clan will form a kill, another clan have a kill like that.
Okay.
So kills are very important. Where
So
the-
like we have
kill
in
people are-
town sector.
yes,
Okay,
even in Kohima village also lordship will find L kill, T kill, all
okay.
this.
Mm,
So they are inhabited mostly by their own
Same.
respective clans.
mm,
So if I see the kill,
mm.
people will know that, oh, he belonged to that clan,
Okay.
like that. So since it was encroached, we approached the kill. That is under the name itself, Ziri kill. Kill was approached. Look, this has happened.
No,
Kindly look into the.
Khel is authority something?
KEL is in the lowest level where any dispute which comes to them will decide. KEL,
Okay,
that is like a sector
okay,
or panchayat, like that,
okay, okay.
not the village council,
Hmm.
below that. So
Are they authorized,
they are customarily, they are doing it,
recognized by the government?
yes.
Okay,
Now, KEL has taken a decision,
Hmm.
neither in my favor nor in the favor of Kenau. But it has taken a U-turn by saying that, no, neither of you are the owners.
Hmm.
The KEL is the owner.
Hmm.
And very interestingly, the KEL has not claimed not only the land in dispute,
Hmm.
but some additional land were also claimed by the KEL
Hmm.
as theirs.
Although they are not the party to the dispute.
Correct,
But
exactly.
now the
Lordship.
judge has become the owner.
Correct, Lordship.
Okay,
And not only that portion, some additional portion of land was also claimed
okay.
by the KEL. So agreed by the decision of the KEL.
No, just a minute. Whether in the Khel, a trial kind of a thing held,
Yes, oral. That's
Oral.
oral, not in the form of a court
how many
proceeding.
days it took, say,
There is no fixed time as such.
say in the instant case? Did it take more than 1 day?
Yes, yes.
Because the moment they receive complaint is in the written form. Complaint.
Yes,
Complaint before the case was in
Yes.
a written form here in this
Yes.
case. So knowing that this is their land, but still then they set to decide.
yes.
Okay.
And so since the KEL has decided in that manner,
Hmm.
matter was appealed before the village council, which is the ethics forum in the village. Village council is looking after the administration of the village and overall supervision of the villages, the village council. Now, the village council took time and have not decided the matter. So having running up our patience, we
Before the
approached,
village, it was appeal or just,
it was in the form of an appeal because KEL has already decided.
is
So
the village
against the
council
decision of the
appellate
KEL.
authority of the Khel?
Yes. So against the decision of the KEL,
Huh.
the village council was approached.
Hmm.
Now, village council have not decided the matter and they were sitting over the matter.
Hmm.
That's why the petitioner, since it is taking a long time,
Hmm.
they have taken the matter to the SDO civil, who is the administrative in charge in the division. Kohima.
Hmm.
So the SDO issued summons to the parties who are involved. But in spite of receipt of the summons, they failed to turn up for the
Whether
case.
whether the appeal before the village withdrawn?
No, they have not decided. That's why, since they are taking a long time
Hmm.
without taking any decision.
During the pendency, you approach SDO?
Yes, because they have failed to take a decision.
Hmm.
So approach the SDO civil, Kohima.
Hmm.
And accordingly, the SDO Kohima has issued the notices to the parties.
Hmm.
But then in spite of the receipt of the notice,
Hmm.
the respondent failed to turn up for the case. Therefore, SDO civil has given a verdict.
Before the SDO, you made party to the
Yes,
Khel or-
I'm the petitioner.
No, you are the petitioner, but then the opposite party, have you also implemented Khel?
Yes, no, KEL was not a party, but the one who has encroached has been made as party. Since
No,
they are
no,
the
you said
affected
that you
party.
have approached against the decision of the KEL.
Yes,
So KEL must be the other party.
no, KEL was not made a party in that proceeding.
No, you said that it is against the decision of the KEL.
Yes, that
Then
is
it-
correct.
Okay,
Against the decision of the KEL, I approached the village council.
okay, making the.
Yes.
Okay, yes,
But then the other
KEL.
who has encroached was made a party respondent,
okay,
not the KEL,
okay.
because they are
KEL,
at court.
KEL decided.
Like, yes, KEL
Set
decided.
as a judge.
Yes. Now, since the STO has issued a summons and it was not responded by the opposite party,
Mm,
STO proceeded to decide the case, ex
Okay.
parte.
okay,
The civil STO Chakama has decided ex parte. So whatever was claimed, that was decided. Now, after about a year, the jury KEL, who has decided, approached the deputy commissioner, saying that, look, the STO civil Chakama has not hurt us. So the point which your lordship is asking, that is relevant here. KEL said that this is an ex parte order, so it has to be interfered with. Deputy commissioner issued notice. On the same day, he has decided that this kind of matter should be decided by the village council. So it was sent back to the village council.
okay. Whereas the case is pending, still pending before the
No.
village council.
That matter was already decided by the STO civil. Since the village
No,
council.
but then you
failed
have
to
not yet
decide-
withdrawn the case filed before the village authority.
Yeah, during the pendency, we approached the STO civil, and STO civil has decided,
Yes.
and the KEL
Hmm,
filed an appeal before the DC,
hmm.
and then the DC
Send back to
has sent back the matter to the village council. That order is without hearing the present petitioners.
Okay,
An order which was passed in my favor. And if it is to be set aside in question, in other words, if it is to be reversed, then I'm expected to be heard. And I have a right to be heard also. But without issuing any notice to me, the matter was referred to the village court. Village council.
is this reference to the village court where earlier you filed?
The deputy commissioner has quashed the order passed by the STO.
No. Earlier, you, before approaching the STO, you approached the village council.
Yes,
Is it the same village
Same,
council where the
same,
decision?
correct,
Okay,
correct.
but then in the village council, the earlier which you have filed, is it still pending there?
he declined to take up the case.
Okay, so
That's
that is,
why I went to STO civil.
that is stated to have been dismissed or,
No, no decision was
Disposed.
taken, but we cannot take up this case.
okay,
So it was taken to STO civil.
but the case was not disposed of otherwise. By the
When
village
the
authority.
moment they say that we cannot take up this case,
Hmm.
matter ends there. The
Okay.
jurisdiction of the
No,
village council.
whether
comes
they
to an
accepted the
end.
complaint, whether they accepted the appeal. The appeal filed by you, or they did not accept itself. The village authority,
They have not accepted that appeal. Rather, village council has directed the petitioner, present petitioner,
to approach STO.
to accept the verdict.
Ach,
So we are not satisfied, so we went to the STO civil.
okay.
STO civil has decided it was preferred, appeal was preferred before the DC. DC, without hearing us, has referred the matter to the village council court. And then the village council has taken a decision again against me. So I filed an appeal before the DC. The most interesting part here, Lordship, after filing an appeal before the DC by the MPN order, that is 3rd July 2024 order. He invoked the jurisdiction under Rule 31 of the Rules for Administration of Justice and Police in Nagaland. In short, 1937 rules. By invoking Rule 31, the learned Deputy Commissioner has decided the case. And if we look at the Rule 31, in the first line itself of Rule 31, Lordship will find that the Deputy Commissioner, after hearing the parties, so matter was pending, filed before the DC, entire hearing proceeding, everything was done by the STO 7. Again,
Okay, otherwise it was filed before the DC, but then DC endorsed it to the SDO.
apparently, but we do not have any document. Whether DC can endorse or not, that is another issue, but DC cannot. But even assuming that there is some endorsement to the STO 7, the order was, the fact remains that the order was passed by DC. We are agreed by that, and that is one of the grounds of our appeal. When Mr. A has heard the matter, A is expected to know about the history and he can pass the order. But here is a case where A has heard the matter, B has passed the order.
Is SDO under the act the equivalent in rank with DC?
No,
So DC is the only.
only
appellate
authority.
Okay.
So when a complaint or a bill is filed before the DC,
Hmm.
DC can pass the order, hear the parties and pass the order. Here, although it was filed before the DC, hearing, everything was done by the STO civil, but ultimately the order was passed by the Deputy Commissioner. Purportedly in exercise of Rule 31. So if we look at Rule 31, I will just read out. Rule 31, clause 1. The Deputy Commissioner, after hearing the parties to the appeal or their advocates, shall pronounce judgment in an open court, either at once or as soon thereafter.
31A or 31?
31, clause 1, page 38. This is amended rules,
Okay, amended.
amendment of
Yes.
1984. First line itself will speak for itself, Lordship.
Yes. Hmm.
So, Lordship, without going into other details, at this stage, it is crystal clear that the DC has exceeded his jurisdiction or abused his jurisdiction for delegating his power to the STO. And after hearing the matter by STO, if STO pass an order, that is all right, in a way. But DC has passed the order showing that as if he has heard the matter and taken the decision. Before pronouncement of the judgment, the parties were called by the DC. That is a fact. They were called and they were asked, yes, whether you want to produce any evidence or you want to rely to any documents. Then the petitioner wanted to insist for looking at the video recording. The video recording of the statement in favor of the petitioner. DC said, no, it will not be relevant at this stage. After some time, the petitioners were informed that we have checked the CD and there is blank. It is blank. There is nothing in the CD. That was the reply by the DC.
Hmm.
So that was ignored by the DC, even going by the facts.
CD was
Forgetting-
produced,
Pen drive, we wanted to,
so entire
Show to
proceeding
the
was
DC.
recorded.
no, regarding some evidence,
Okay,
we wanted to show. But then DC declined to see that on that particular day. Later on, the DC said there is nothing in the pen drives, blank. That is what we were informed.
so is it
And-
the case where the SDO recorded the evidence like the district judge endorsed, session judge
Yes.
endorsed JMFC to record the evidence? Is it the case?
No,
It's not like
that
that.
is not an issue.
Hmm. But only the, here is the case different in the sense that the entire matter was heard by SDO and an order passed by
DC.
DC. So
Without
It's a
going
case
into
of-
other detail,
case of material irregularities.
yes, we have taken a ground also, that material irregularity. And in 2014, besides that,
Hmm.
going by the facts, in 78, there was a decision in our favor regarding this land. But the DC has ignored that also. There was a map. Map was also ignored. And CD recording was ignored. Way back in 2014, a MOU was signed with the tourism department where one of the clans who were claiming the land was also a signatory, village council was also a signatory to that MOU entered with the Department of Tourism by the petitioner's clan for construction of the Doris rest house. This is near that Tsuku Doris spot. So this is a place which is on the way to Tsuku, a rest camp, which was constructed with the consent of the village council, where the village council is a signatory to that MOU signed between the Department of Tourism and the petitioner's clan, where the village council was a signatory to that this land belongs to the Tsuku clan, and they are giving it to the tourism department for construction of this. Because in the villages, unless there is some written document, at present, it will be very difficult that some other persons may come and claim like that. So that was also totally ignored, absolutely silent, as if nothing is there. So all these things were ignored by the DC, but in short, we are agreed by that misuse and committing material irregularity. That is one of the grounds in the present appeal. So at this stage, my only prayer is, Lordship, since it is in a village, it is very sensitive, as I was mentioning in the initial stage. Kindly have a look at the page 100. Last page. That is a translated copy of what is happening. When the DC has passed an order, page
100.
200, last page, Lord.
200.
200.
Yes.
This is the translated copy. They have issued, village council has issued this on 16/7/2024. And then reconciliation program was organized on 20th July 2024. When the order was already passed by the DC, what is the need for organizing a program for reconciliation? This is because of the fact that this is only yesterday they have,
What is
the
it?
order which was passed on 20th, that is a translated copy, that they are compelling the petitioners to sign, to accept the decision of the DC. And I don't know what will happen if we fail to accept this again. So far we have declined to sign.
So who are these who have put their signature?
This is other two clans. Serial is the Kel, that is the Kel Panchayat, serial number 1. Serial number 2 is the petitioner's clan, Chakro Sara. Number 3, Tenusali Sara Sono. They have signed because everything is already organized and it's being done in a synchronous manner so as to deprive the rights of the petitioners. And Lordship may appreciate one aspect of the matter arising out of this issue. At one point of time, of course, we lodged a complaint to the DC and the DC have issued direction to the village council. Ration cards were deprived. Our clan members were deprived of our ration cards. Indigenous inhabitants certificate, a recommendation is to be issued by the village. That was also deprived. ST certificate, excommunicated from the village. So many orders, adverse orders have been passed during the pendency of this, after arising this issue. Since we are only a clan which is minority in the village comparing to the large number of population in the village. So village council is punishing the petitioner's club. And even here, when the authority has already passed an order, rightly or wrongly, the deputy commissioner's order, which is embryon in this present petition. When the order is there, when the order of the authority is there, in spite of that, they are organizing this program so that they will compel us to sign. And once we sign, all our rights will be gone. Because ultimately they will come and say that, look, deputy commissioner has passed an order and the village council have organized a program on 20 July 2024, and you have also signed in this. You have accepted the judgment. This is nothing but to accept the judgment. How you can force somebody to accept the judgment? Even if it is illegal, since the order has been passed, you should. Even the order passed by this honorable court is being challenged before a division bench, before the Supreme Court. That is the right of a citizen to seek remedy in the appropriate forum in a democratic manner, in accordance with law. Otherwise, what every person can do.
So let us see the impugn order, which you are impugning.
Indian order also will find at page 192. Passed by the deputy commissioner. It is clearly mentioned in the first paragraph itself that by invoking the provisions of Rule 31, the DC has passed the order. So this is enough without going into other details. Without hearing, he has passed the order. Although the order says that as if he has given the opportunity, that opportunity is before the STO civil. The point which we have raised before the DC has never been taken into consideration. And many irrelevant things have been brought in.
You have appealed the decision of the village council dated 15/9/2022.
Yes. And again, another surprising thing. The DC has relied on an order of the British government, that is 14/3/1935, allegedly passed by the Deputy Commissioner, Chief Mills. That order, the existence of that order, nobody is sure. And apparently the Deputy Commissioner and the Village Council has decided, because Village Council has decided passing on this order, DC has also relied on that.
Whether the order, copy of the order was produced?
No, it was never produced. We have taken specific ground on that.
Who produced it? Who brought it to the knowledge of
The
that?
Village Council is saying that there is an order. Where is the order? We have also not seen.
Whether, was it apprised or submitted by the opposite party?
No, it was not. That document was not available on record. So from where that point came, what I suspect is, if we show a whole order passed by the petitioners, then the authority may believe it and accept it as possible truth. So let us go by that line. If at all there is any order, let the parties place and show. Even during the proceedings, STO has insisted for a copy of the order passed by the Chief Mills.
Passed by the?
Passed by Chief Mills. That is during British time, Chief Mills. He is an anthropologist. He has written few books. He has written out the Au Nagas. The Angami Nagas is not by Hotom. And 2 or 3 books were written about the Nagas by Chief Mills. He was at one point of time the Deputy Commissioner.
Okay.
Let there be a rubber tribe. in appropriate forum. And the petitioner feel that there should be a proper trial. By affording opportunity to put the parties, the matter can be decided.
Okay, so the deputy commissioner by this order, impugn order, upheld the decision of the village authority 59/22.
Yes. And he has exercised the power basing on Rule 31.
Where have you stated that because revision in the revision jurisdiction, there is a limitation.
Yes. But
So where
when
have
there
you
is
stated?
when there is jurisdictional error, definitely
Yes,
lordship can invoke the
jurisdictional error and of course, material irregularities. So where have you stated in the,
paragraph 35. Page 22.
yes,
That the petitioner submits that the matter was heard by the STO Civil Jakama and the deputy commissioner proceeded to pass the impugned judgment on 3/7/2024 in exercise of Rule 31 of the Rules for Administration of Justice and Police in Nagaland, 1937. So they have quoted the rule, but this is the old rule of 31. But the new rule which I have shown to your lordship is different. And can we come to page 25?
yes.
Page 25.
Hmm.
If in middle of the page that the decision rendered in 1974 has not touched the boundary of the Sucro River, but the finding in the impugned order indicates that the boundary demarcation was done beyond Sucrui River. Therefore, the said finding arrived in the impugned order suffers from material irregularity. So this is one of the grounds we have taken. Material irregularity to
But this is not a case of jurisdictional error.
Lordship, that's why
Hmm.
when the STU civil has
Yes.
heard and DC has passed the order,
Hmm.
it is abuse of jurisdiction.
Material irregularity.
Another person will hear and another judge will pass the order. Then what kind of a order we can expect in such a situation?
Yes, state. Hmm. Yes,
Since there is also a private respondent lordship, at this stage, notice may be issued. And I will
Okay.
accept notice on behalf of respondent number 1, 3, 3,
1 to 3.
lordship. Steps.
I will take steps by registered post to the remaining respondents.
Mr. Zamir. City Zamir. Ghana Senior Advocate, assisted by Mr.
I am Chen.
I am Chen. Ghana Counsel for the petitioner. Staff. I've also heard Mr. Jimomi appearing on behalf of state respondent number 1, 2, and 3. Staff. By filing this petition, the petitioner assailed the impugn.
It's 192.
Judgment and order dated 3/7/2024, passed by the Deputy Commissioner Kohima, Nagaland, in Civil Appeal number 01/2022. Alleging that although the appeal was filed before the Deputy Commissioner, the matter was entirely heard by the STO,
Civil,
Civil, Yakama,
Kohima,
Kohima,
Chakamalo.
Yakama. And the judgment was passed by the deputy, and the judgment was passed by the Deputy Commissioner. And thereby committed a material irregularities. Committed material irregularities. And thereby, the Deputy Commissioner acted in exercise of jurisdiction with material irregularity. Stop. Para, issue notice. Returnable by 4 weeks. Since Mr. Jimomi accepted notice on behalf of the state respondent number 1, 2, and 3, no formal notice required to be issued to the said respondents. However, the petitioner shall serve requisite extra copy to the learned State Council during the course of the days. Stop. The petitioner shall take steps upon the respondent number 4, 5, and 6 by a registered post with AD
1 week.
within a week from today. Stop. List this matter after 4 weeks. Okay.
Regarding the interim, unless there is some interim direction, the village council will resort to all this kind of activities basing on the disease order. They may even try to demarcate the land basing on this order. Therefore, some protection may be given.
Having regards to the contention made in the petition and the contention made in the petition and the submission made by the land council for the petitioner. It is provided that what steps they are likely to take, you said?
They may demarcate the land. Secondly, like before, they may impose so many actions against the petitioners. Therefore, pursuant to this, unless this impugned order is suspended, then on the strength of this order, they may resort to so many illegal activities, lordships.
The operation of the impugned order dated 3/7/2024 shall remain stay till the next returnable date. Good. Yeah.
Much appreciated.
For admission, item number 1.
No, Mr. Lordship. I'm appearing on behalf of my senior, Mr. Supamwati.
On behalf of,
My senior, Mr. Supamwati.
okay, what do you want here?
I pray the matter be listed on next Friday.
Just a minute. What was your submission?
Lordship, I was mentioning to list the matter after 2 weeks, Lordship.
Oh,
So
you also need,
in that way of the matter, Lordship,
okay,
if this matter can fix.
on the joint prayer made by the Lana Council for the petitioner as well as the respondent, list this matter after
2 weeks, Lord.
2 weeks.
Your Lordship, the interim order passed.
There is interim order also.
But
The interim order passed. And the interim order passed earlier, shall continue till the next date. Okay, obliged.
For admission, item number 2.
Okay. What was the, this is. Yes, what was the prayer?
Lordship, as per the last order, that is 9/7/2024, we made all the payments to the respondent. And in effect to that,
The amount of rupees 175
yes, Lordship,
has been paid to the respondent number 2.
yes,
And the
Lordship.
agreement to that effect will be executed. So you want to execute the agreement?
Yes, Lordship. We are facing some difficulties since petitioner is stationed in Delhi.
Station in?
In Delhi.
Okay, so
So in order to-
sign could not be obtained.
Yes, Lordship. So we need 2 more weeks.
Well, my prayer, my humble submission is if there's no conflict dispute between the parties,
Hmm.
I wait for that agreement because I think.
Yes, if they have already submitted before this court,
Yes.
that there is an agreement and have paid, and if we acknowledged the payment receipt. Just a minute, Rama Sujit. So the respondent number 2 is the informant in the FIR.
Yes,
Lordship.
You are for
Respondent number 2.
respondent number 2.
Yes.
What is the offense involved? You have no objection. Okay. You have received the entire amount. Then I think it may not be required also. It's a no. Because they paid some amount. You could not, and then you met your effort. Huh? But then since could not be admitted, so ultimately want return, and then ultimately entire amount has been returned.
Yes.
So I think there's no case.
It will be just a ritualistic formality, Lordship.
Yes, yes. So we'll dispose of.
Lordship.
You have any problem?
No, Lordship.
Okay, you have any problem? We'll dispose of, okay. Mr.
Manan. Lordship, I'm appearing on behalf of my senior, Mr. Cindy Younger.
Your name is also there,
No, Lordship,
appearing on behalf of Mr.
Cindy Younger.
Santiago, Land Council for the petitioner. So. Also had Mr. Angami, Land Council, appearing on behalf of the state respondent. And Miss,
Ayala Engine.
your name is there?
I'm appearing on behalf of my senior, Tombak Pangani.
Your name is not, is also not there.
Yes, Lordship.
I,
Ayala Engine.
I'm in Chen.
Yes. Ayala.
Spelling
Ayala.
AY,
ALA.
have you written? Yeah, in Chen. Have you written? Okay. So for respondent number 2, start. No? Take seat. Sit down, take seat. Let me take that the material, particulars, then rest. Okay. Para. Okay, there is two accused. Two.
Petitioner one, Lordship, he's the accused in petitioner number 2. He's a accountant of the firm.
But then allegation is against both this petitioner. Case registered against this one petitioner number 1 and 2. Okay. This is an application filed under section 482 of the Criminal Procedure Code 1973. By the petitioners praying for passing of the case has already been charge sheeted. No. Of the criminal proceeding being GR number 340/2022 in connection with Magifema PS case number 0009/22 under section 406, 409 and 420 IPC. Oh no, it's pending before the JMFC only. GR case arising out of the Magifema PS case. Not connection, arising out of the Magifema PS case number 0009/22 under section 406, 409 and 420 IPC. Pending before the Learned Court of Judicial Magistrates, first class, Dimapur, Nagaland. Stop. Para. The case of the petitioner in brief is that the petitioners runs a firm by the name and style of Education Guidance at Bhikaji, BHIKAGJI, Kama Place, New Delhi, which is engaged in the business of giving educational consultation to children and their parents, stroke guardians, stop. In 2019, the respondent number 2 approached the petitioner's company seeking admission for his child for Master of Business Management course and had agreed to pay rupees 5 lakh. Stop. He then transferred rupees 2 lakhs in the firm's account, and the rest rupees 3 lakhs was to be paid after his child's admission. Stop. Thereafter, his child got seat in MBA course through management quota. Stop. However, the respondent number 2 refused to pay the management fees and asked for normal fees, which was not possible. Stop. Therefore, in the month of October 2019, the respondent number 2 himself cancelled the admission and asked for refund of the rupees 2 lakhs that he had paid to the petitioner number 1 and 2, to the petitioners staff, petitioners farm staff. Stop. And thereafter, on 8/11/2019, rupees 100 was transferred into the account of the respondent number 2 as testing to check as to whether the account actually belonged to the respondent number 2. Stop. Thereafter, on 18/11/2019, rupees 25,000 was transferred into the account of respondent number 2 by the petitioner number 1. Stop. Para. However, surprisingly, on 3/2020. The petitioner number two, sorry, the respondent number two lodged a written FIR against the petitioners before the officer in charge, Majifema, PS, Dimapur, Nagaland, inter alia alleging therein that he had deposited rupees 2 lakhs in the account of the petitioner's farm, in the account of the education guidance Ansel Chamber 1. Then petitioners, account of the petitioners for the admission of his daughter in MBA course after getting full assurance and promise from the petitioner number two, working as consultant in education guidance, working as consultant in education guidance, start. It is further alleged that the petitioner promised to confirm the admission of his child by the end of June 2019. Stop. However, when he contacted the petitioner number two replied that the admission process is still going on, and it might take time till the month of August. But when he contacted in August, the petitioner replied that there is no chance for admission for his daughter stop. So he asked to return back his money The petitioner assured that after closure of admission process, the money will be deposited back in his account. And on being asked by the petitioner number one, he has also given his bank account detail. Stop. However, after depositing only rupees 100 in his account on 8/11/2019. The petitioner has not, sorry, the petitioner is not responding his phone call, not responding even his phone call, nor his message. Stop there, hence requested for taking necessary action. Stop. Basing on the above FIR, written FIR, a case was registered being the above Majifema PS case was registered against accused under section 420 and 406 IPC. Do you have any idea that the case has been charge sheeted? Mr.
Because on the first day, on 16/12/2022, the investigation was stayed.
Uh,
Was suspended by this honorable court, Lordship.
Suspended the investigation or
Yes.
the
Investigation,
Right.
Lordship.
investigation?
Lordship.
So they have mentioned it. No, they said they're pending before the JMFC. Pen. Put on the pen. Accused was not arrested,
No, Lordship.
so no anticipated bail also applied.
No, Lordship.
Okay.
Lordship, Annexure 6 is the order passed by the GMFC.
Hmm?
Annexure 6,
Page,
page number 24. It is the order passed by the district.
okay, arrest warrant.
Lordship, my apology, it was not suspended, but no stringent action was supposed to be taken against the petitioners during the investigation. That was the order first. My apology, Lordship.
Okay. And investigated into, register under so and investigated into, stop. Para. The Learned Counsel for the petitioner submits that. On the demand made by the petitioner number 2, comma, sorry, the respondent number 2, comma, the petitioners have already returned a sum of rupees. It should be a paragraph above this, Return a sum of rupees 1,85,100 on different occasions. However, that will come, okay. However, that paragraph, however, by hiding all these facts, the companion laws written FIR, that will follow, okay. The para, down below then, the Learned Counsel for the petitioner submits that during the Learned Counsel for the petitioner submits that during the pendency, okay. Stay is okay. The Learned Counsel petitioner submits that by an order dated 16/12/2022, this honorable court has directed not to take any stringent or coercive measures against the petitioners during the investigations. Thereafter, the investigation did not proceed.
I don't have the exact information, but however, Lordship, what I learned from my learning friends that it has not reached, it's not gone for trial, roughly. It is clear.
It hasn't reached to court. The court case has not yet been charge sheeted.
Nothing of that sort. No,
Charge sheet not yet filed.
yes, according to my.
So thereafter, the investigation also did not proceed probably, or proceeded.
Not properly, Your Lordship.
Hmm?
Not properly, investigation also. Actually, while the matter was being pursued, the petitioner, they filed this instant criminal petition for stay of the
Okay.
proceeding.
Thereafter, okay. And during the pendency, of this petition and the investigation, comma, the parties have amicably settled the matters and then the respondent has filed any affidavit. Okay.
Yes,
No
Lordship.
objection.
Respondent to.
Okay, start. And then during the, by the mutual settlement, you have paid entire amount. Have you mentioned somewhere amount?
Lord, may I please, Lordship,
Yes.
after the payment was made to me by
Hmm.
them, the remaining 1,75,000.
Hmm.
This honorable court directed us to make an affidavit, to file an affidavit.
Yes. So, okay. It is also denied. Okay. It is not denied. Mhm. Now, after receipt of the entire amount, have you made affidavit, have you filed
No,
affidavit?
no such thing has been filed yet.
Okay, but then in the affidavit, you have objected. No. So. Mr. Angami? Yes. The affidavit filed by them.
After filing the affidavit,
Yes.
then only, after that only, they have made the
Paid.
total payment to me.
So because affidavit so far is that they are objecting and praying for dismissal. So probably they need to now make small affidavit.
Yes, Lordship.
So otherwise on record, there is no agreement.
Yes.
So here you
That's
have
why-
objected
Yes, this.
and then you are praying for dismissal.
Lordship.
And then he has also filed affidavit in reply
Yes.
controverting those.
Yes.
So it will be difficult at the moment. So
Yes.
so file by Monday or Tuesday,
Lordship.
file one small affidavit saying that
Yes.
it has been amicably settled because there is no record as such.
Lordship.
Amicably settled whether sign or not, amicably say that you have received the entire amount. Now, no more grievances against the petitioner and amicably settled, no? So the respondent may also file, okay,
Lordship.
apprising that you have received.
Lordship.
And in the meantime, whether the charge sheet has filed or not. Okay, and then just verbal instruction. Okay,
Lordship.
so keep this, we'll continue with this by Monday or Tuesday. So you file by Monday and then we'll take it up on Tuesday.
Lordship.
Okay. So what we'll say, simply will say that to fix on for Tuesday. Okay. Next Tuesday. But it will remain only, we'll dispose of in continuation of this. Okay. Because this will be order dated on Tuesday only, not today. Okay. Now, now counsel for the petitioner. Mr.
Manin.
He is present. Mr.
Lakney form for respondent two.
Okay. Okay, respondent number three. No, sorry. Angami, huh? Maybe Angami, Lara counsel. For the state respondent. And Mr. Lakma, Lakma?
Lakney form.
Lakney form. Lara counsel for the respondent number two are also present. Stop. Age prayed for by. Okay, the council now. For the parties. Praise for allowing them to file affidavit. The last occasion you made a prayer. Yes, to file petition. Praise for allowing them to file affidavit, bringing into the notice of this court about the agreement entered into by the parties. The prayer is allowed, list this matter on Tuesday, huh? What?
Lordship.
그게 아니에요. 게스트들이. 나중에 Dispose bana bir şey olmuyor. Ready buna gitse. Change. Gimana ceritanya? Disposal cerita lagi na. Papers in. Ush. Apa? Pwede deh. Dia juga kewat di na. Holding method. Yung. Itu din lagi deh. Di bajilana. Apa ayo? Jadi tahan. Itu costly cerita deh. Ekta tuh judge kita boleh. Alfred tuh. Aku bisa. Tadi dulu baru maksudnya. Tadi absen cuti luar itu deh. Yes.
Suppose that I'm the people in over there.
Ah.
So suppose that I'm the people in over there.
Ini kota aku lagi.
But please, the guy carry. Will have a.
Senior most aja. Aduh. Itu masih mana? Ini pun nak kau kosti sampai dua. Jadi kayak gitu nggak kosti.
Procedural na lagi mo ga just siya.
Itu aku tuh.
Bisa se.
Ah.
Bisa pun na kan bisa se.
Saya ISO bench sorry. Kita naga bench na take up sudah jadi lah. Di sini. Ayo. Ah. Di sini mana bahar aja sih mau aja kalau di situ.
Bisa na ako bisa na dia lagi na lagi tayo. Itu na. Itu na na.
Tanku dulu.
Thank you.